So good day, everyone, and welcome to day 2 of our IP Bits and Bytes intellectual property webinar. For those of you that were not with us today, just a reminder on yesterday, pardon me, on day 1, just a reminder of a few housekeeping items. I guess first, just a recap on sort of today's objective. Our webinar is intended to provide you with some very brief but core concepts to the topics that we're presenting you on. And we will be recording this webinar, and the recording and the relevant documents will be available to you in about a week's time. An additional reminder that questions can be submitted through the webinar via the chat function at the bottom of the screen. And we have planned to dedicate some time at the end of the webinar to cover those questions and hopefully get to all of those questions. Our speakers' bios are available on our webinar page, as well as on our Dentons website. This session is accredited for 45 minutes with the Law Society of British Columbia and the Law Society of Ontario, and it is accredited for 1 hour and 15 minutes for Barreau du Québec members. If we can move to the next slide, please. Great. Just for a recap of day 1, I think we have a slide for that. We thought it might be helpful for some of you that may not have been with us yesterday, just to give you a really high-level overview of day 1. Carla, do we have a day 1 recap slide that you can put up? Okay, while we're working on that, we began the day with a innovate on a strong IP foundation topic. And what we discussed there was really the importance of understanding, identifying, and protecting your IP promptly and regularly within your company. Timing is very important. And so it is important in terms of protection within your company and your innovation. And so we provided a bit of an overview, if you recall, in those slides, and what you'll see when you get them next week, a bit of an overview of really the 4 corners of IP. Following that, Bob Tarantino talked about the protection of music, and he talked about the different licenses that are available. There was a pretty complex checklist, actually, that he shared with us that those that would like to use songs in commercials or advertising need to be familiar with in order to obtain all of the approvals and licenses required. Great, thank you. Following that, Jennifer McKay spoke about trademark registration and the benefits of trademark registration. And finally, Matt Diskin and Meredith Bacall talked about fair dealing in copyright law. There was less of a focus on parity and more of a general discussion around copyright law and damages applicable and how disputes with third parties can arise. And so with that, we'll move to today's agenda. And our first speaker is a senior associate from our Calgary office. We have Sam Gabor, who is going to be talking about the depreciation of goodwill under the Trademarks Act. So Sam, over to you.
Great. Thanks, Paniota. And thank you for everyone on the line. I hope the information I provide is helpful and everyone takes something away from it. So I am a trademark agent in the Calgary office. And a lawyer with Dentons. I'm going to be speaking today on Section 22 of the Trademarks Act, which is essentially the statutory protection that helps registered trademark owners prevent depreciation of the goodwill of their trademarks. And essentially what Section 22 of the Act says is that no person shall use a trademark registered by another person in a manner that is likely to the effect of depreciating the value of the goodwill attaching thereto. So there's statutory protection available to registered trademark owners, and that's the important point that I emphasize. You have to be a registered trademark owner to get this goodwill depreciation protection under the Trademarks Act. And that sort of tunes back to Jennifer McKay's presentation yesterday on the importance of obtaining trademark registration. So that's just a sort of intro point. Essentially, what goodwill connotes is the positive association that attracts customers towards the owner of goods and services rather than their competitors. So it's essentially the attractive force that brings customers into a company's business. That's what goodwill is. Goodwill can reside in trade connections. It could reside in particular premises. So let's say, for instance, Good Life Fitness has a well-maintained gym facility. They have goodwill in the space and structure that they provide to consumers and people that like to work out. You could have goodwill in the experience you have in a specialized sphere, or just reputation in the name alone. So essentially, what goodwill is, it is the effort that's created and generated by a business that adds value to it. And essentially, what Section 22 of the Act is meant to do is to prevent the goodwill that a business has in their trademarks from being blurred or tarnished or depreciated by a third party. It could be a competitor or any third party. So that's one difference that I point out is two sections of the Trademarks Act deal with trademark infringement, and that relates to confusion between a registered trademark and another trademark. For depreciation of goodwill, you don't actually have to have confusion between the two marks for you to be able to rely on Section 22 of the Act. So that's the big difference between trademark infringement and a claim in depreciation of goodwill. And as I'll talk about the two cases, the Budway case and the Herbs R Us case, the court specifically looked at trademark infringement and depreciation of goodwill and broke down why one of the cases had trademark infringement and the other one didn't, based on the statutory test, and why depreciation of goodwill actually provides a good backup for a registered trademark holder who can't actually prove trademark infringement. So if you can go to the next slide, please. So there's a 4-part test to prove depreciation of goodwill. And the first part is that the claimant's registered trademark was used by a defendant in connection with goods or services, whether or not the goods and services are competitive with the claimant. So again, I'll talk about in the two cases, you don't actually have to have the two goods and services between a registered trademark holder and a competitor being the same for there to be a depreciation of goodwill and having recourse under Section 22 of the Act. So the first part of the test is that the claimant, or the defendant actually uses the registered trademark holder's trademark. And the court is going to look at whether the trademark has been used by the third party on their packaging, on their labeling, and their goods are sold to consumers, or if they've got services where the trademark is displayed or advertised. So I'll talk about in the cases, but there's some examples there that we'll discuss. The second part is that the mark owned by the registered trademark holder is sufficiently well known. You don't have to actually have a famous or significantly well-known mark to be able to get protection. You just have to have it sufficiently well known. So it's a lower standard. And essentially what the courts are going to look at, and these will sort of be in my takeaways at the end, is the court's going to look at your volume of sales, how much market penetration you have, what kind of advertising and publicity you've achieved over the years, how much money you're spending, how far your geographic reach is. You know, are you just selling in a small community, or are you selling across Canada and all North America? Your inherent degree of distinctiveness. So marks that are what I call coined words, that are, you know, marks that aren't dictionary words, and they're very precise. So like Panasonic, Sony, those are very inherently distinctive. So if you have another mark, say called Sori, S-O-R-I, and they're selling electronics, out of a back door shop or something, right? I would say you have a good claim for depreciation of goodwill if that were to occur, because Sony is a very inherently distinctive mark. And the extent to which the mark is known in sort of the particular quality. So that's the second part the courts are going to look at. The third is whether the marks have linkage to each other. So the court's going to look at whether the registered trademark was used in a manner likely to have an effect on the goodwill of the registered mark holder. So essentially what the court is looking at is there some sort of linkage, connection, or mental association that the test is a somewhat hurried consumer would have. So if I'm a somewhat hurried consumer and I look at one mark and I go, is that associated with this other mark? Then you have an argument that there's that mental linkage between the two. It's different than the test for trademark infringement. And essentially what has to happen is the consumer has to think, even subtly or subliminally, that the marks are associated with each other and that they're linked to one another. But there actually has to be an impact on the goodwill of the party. So even if there is a link, right, it actually has to have a real impact. So if I go, okay, yeah, maybe they're the same, but like, I know they're clearly not, then, and it has no impact on the business goodwill whatsoever, then there's no linkage. And the fourth part of the test is that the likely effect of the use would to depreciate the value of the claimant's goodwill. So this is sort of your damage factor. So you have to prove that the use actually reduces your reputation and your goodwill, and you have to have actual evidence to do it. Now, the court can infer that depreciation will occur and that you suffer damages, but they want to see some sort of evidence. And sort of the last part is what's your remedy if this were to occur? Generally, what happens is what you're trying to get is the third party ceasing use of the trademark that they're using. So you're going to ask for injunctive relief. On top of that, you may ask for damages or some sort of loss of profit, but there may not be very much because you may just have a small third party trying to use your goodwill to sell their own goods and services. So it may be a nominal amount. And that's what happened in the cases I'm going to talk about. And also the court actually has the discretion to not award damages, and they actually have the discretion to allow goods and services to continue to be sold, even if there's a depreciation of goodwill. So that's generally the case if there's some innocent use and there's not actually any depreciation, but that's sort of the court's out mechanism if they feel like that there shouldn't be a remedy granted. So the two cases I'm going to discuss, if you can go to the next slide, please, are the Toys R Us versus Herbs R Us case and the Subway v. Budway case. These were both out of the federal court, and the area that the facts took place in were in Vancouver. So the Toys R Us case, everyone knows what Toys R Us is about. They sell toys and family products. Herbs R Us was displaying their mark on signage in downtown Toronto, and they were a cannabis dispensary. Toys R Us brought a trademark infringement, passing off and a depreciation of goodwill lawsuit against Herbs R Us to attempt to get them to stop using that mark. In both cases, this one and the Budway cases, neither of the defendants responded. So basically Toys R Us and Subway just had to get into court and prove their case. So it'd be interesting to see if one of these cases in the future, there's actually a defense to see how they argue it. So, but in these cases, there was no defense. So Toys R Us was not successful on either its trademark infringement or passing off claims against Herbs R Us, because the court said that because Toys R Us is selling toys and family type products, and Herbs R Us is a cannabis dispensary selling cannabis products, consumers are going to know that they're not associated with one another, and that Herbs R Us is not the source of goods from Toys R Us. So basically, they looked at the 5-part confusion test. One of the parts is, are they selling similar types of goods and services, and do they have different areas of trade? So are their consumers different? And they said, based on those 2 factors, there's no trademark infringement, there's no passing off, because there's no confusion. Like the consumer is going to know that they're different sources of goods and services. But Toys R Us was successful on the depreciation of goodwill claim, and they went through the court went through the 4-part test, and they said Herbs R Us was using its mark and using essentially the Toys R Us mark that had such similarities that they met that Toys R Us met the first factor. They also said there was a mental association between the 2 marks from a casual consumer, so there was that linkage. And then they also pointed out that there were news articles that came out that specifically drew attention and linkage between the 2 marks. That was just a third party that provided that evidence. Toys R Us has significant goodwill. It's very well known and a very strong brand throughout North America. And the court said that they would suffer damages and their goodwill would be depreciated. They essentially said that Herbs R Us was bandying and blurring the Toys R Us brand, and it was whittling away its goodwill. They were also concerned that Herbs R Us was a cannabis dispensary, and the evidence showed they didn't have a license, and had social media with adult themed content, with nudity and swear words, and this was totally inconsistent with the brand and reputation of Toys R Us. So those as well too were depreciating the goodwill that Toys R Us had. So ultimately they granted an injunction and awarded $15,000 in damages against Herbs R Us. The second case was Subway and Budway. Very similar facts. The Budway company was running a dispensary, and I've sort of seen photos in the news. It looked like a sort of a rundown back alley they were running their business out of. So Subway brought a trademark infringement, passing off, and depreciation claim, just like in the Toys R Us case. It was the same judge that heard both cases. But in the Subway case, it was successful on all 3 claims because what the court found was that because Budway was selling baked goods and Subway sells baked goods, that they had overlapping goods and services, that there was trademark infringement and there would be confusion between the 2 with consumers. So they were successful on trademark infringement, and then they were successful on depreciation of goodwill as well too. The Budway mark was being used, and it was closely akin to the Subway mark. They're almost identical. Obviously, Subway has very strong and significant goodwill. There's clearly a linkage between the 2 marks and a mental association between the 2 when you look at them. And in fact, Budway had a sub sandwich mascot in front of their location on the street that was smoking a cannabis cigarette and pointing people towards the store. So the judge, I don't think he appreciated that, and that was sort of further evidence to show the linkage, and that Budway was purposefully using that mark to use the goodwill of Subway. And then there was damages, and he awarded the same damages in this case as in the Toys R Us case. So if we can go to the last slide. So the takeaways I would say from the depreciation of goodwill and how to use it as a tool in your ability to protect your trademarks are first is apply for trademark protection, because you can't rely on this section if you are not a registered trademark holder. So I would say get your trademark application in, because once you're a registered trademark holder, you can rely on this section. The second is maintain good files of your sales data, your advertising costs, your revenues, consumer surveys, consumer recognition, where your mark is being used throughout the world. You want to really maintain a good file of all that evidence, because eventually if you are going to have to sue for trademark infringement or sue for depreciation of goodwill, you're going to need that evidence before the court to be able to prove your claim properly and show that you have sufficient goodwill. So keep all that information well organized and update it, I would say, and biannually or annually or quarterly, whatever you feel you need to do and have the capacity within your own systems. But very important to maintain that information, because you don't want to be scrambling to get that information together when you may need to get into court very quickly. So for instance, in the Budway case, the signage came up and they were needing to get into court very fast. So you got to put that information together for your legal counsel to be able to get into court quickly. So it's important to keep that very organized. The third is to monitor your trademarks. There are monitoring systems, but that is more so for people applying for trademark protection. In this case, develop systems where you have people on the ground potentially keeping their eye open for third parties that may be depreciating your goodwill. And the fourth is police your marks and enforce your rights if there exists depreciation, even if you don't think that there's confusion between the two marks, and even if they're different goods and services. Trademark protection is sort of a use it or lose it game. If you don't police your marks and enforce your rights, you sort of depreciate your rights in the marks. So it's important to actually move forward and enforce them accordingly if there is depreciation or trademark infringement. Those are my comments and my presentation, and I'm now going to turn it over to my colleague Tom Sides, who's going to talk about machine learning and AI service contracts.
Great. Thanks, Sam. Appreciate that. Just driving up the Highway 2, QEW from Calgary to Edmonton. That's where I'm located. I head up our technology transactions group nationally and have been involved working with a number of machine learning, artificial intelligence companies, and thought this topic might be of some interest. It's, of course, in the context of intellectual property. There's some other elements, legal elements, that I'll just touch on briefly in my presentation. So with that, I'll just go to the next slide then, please. So to talk about this topic, you don't need to be a data scientist. First of all, I'm not either, but there certainly are a lot of data scientists involved in this area in the companies that we work with. And we've all heard, I think, over the last number of years about data, and especially big data, and how important it is. And as we live in this technological era, as we know, a lot of the information or data that we relied on previously in the physical form has been digitized. So that is the form in which it takes in most of our evolving society in terms of the innovative aspect of it. And so data has become king or queen, depending on how you look at it, in terms of its value in this technological age. And it's really used to mine for companies to find different ways to be more efficient and effective in what they do. And that's the data part. And as you can see, I've given a definition. There's many definitions that exist for all of these. I tried to come up with some that are going to be somewhat intuitive for people, and you'll have my slides for later on, so hopefully you can read them and understand a little bit about some of these building blocks. Machine learning really is the next aspect, and it's really the most important part in today's world. when you talk about machine learning or artificial intelligence, most people will focus on artificial intelligence. I guess that seems sexier for people to have it occur on that basis. But machine learning is really the brains, the guts behind it, and that's what really drives the commercial use of big data, machine learning, artificial intelligence. So the big data is the feedstock for machine learning algorithms, right? And the AI itself, the artificial intelligence, sometimes I'll call it artificial intelligence or just AI. It's a system or software, just in terms of using some terminology. So the AI really is designed to unlock the value of the big data. And the machine learning is a technical mechanism that facilitates the AI. It's really, I guess another way to look at it is like big data analytics on steroids. So this sets the framework. Now, when we all look at a lot of the advertisements that appear, even in areas like golf, everyone seems to be using AI. We use AI. Everything's powered by AI. I don't know if that's necessarily true, but I guess it has a certain appeal in terms of the technological advancement and how it can improve the business. And I think people find it rather alluring as far as a new development. When you talk to the experts about it, and they talk about the concern people have, technology phobia, and the world getting taken over. Think of the Arnold Schwarzenegger Terminator movies, etc. People have had concerns, starting off with the first industrial revolution back in England in the in the 1800s, etc. And in some respects, people have the same fears of artificial intelligence, and people seem to go conventionally to situations that are catastrophic, where we have robots taking over the world. And what was that one movie called Skynet, something to that effect. But we're not there, and most experts would say that what we have now currently is narrow AI, which means that machines perform a narrow set of tasks, and they're applied to a fairly narrowly defined problem. And probably the best example is an autonomous driving vehicle, which most people know about. So let's go to the next slide, please. So I always like these cartoons, and it's not even very accurate, I guess, but it kind of describes a shift in terms of computing and what we kind of experienced, or at least some of us of a certain age, in terms of technological development, the typical kinds of AI, or as we would call it in the past. And as you can see the slide on the right, it's obviously more advanced in predicting the future, if you will, and all your needs. And in some respects, that sounds very attractive, and I think it's what we're all looking to in some respects. But the applications with AI are quite practical nowadays. As I said, an automated driving vehicle is obviously something new, but it's not basically replicating information on itself, not yet anyway. It is performing functions according to computer programming that's quite static. So let's go to the next slide, please. So I just thought I would put this down. This is a client of our firm's, LTML. They're a rather large, in Western Canada anyway, developer of machine learning and artificial intelligence solutions. And this is their practical approach to it. They use the term applied artificial intelligence because there's a lot of research still in the area. Another company that we act for, Alberta Machine Intelligence Institute, more on the research side, but certainly trending into the commercial applications as well. LTML focuses on the applied artificial intelligence solution. So I just thought I would indicate to some people some of the use cases that LTML has experienced that tell you, I guess, the practical applications they're looking to provide to their customers. One is automating production lines, which of course would be very important, for example, in the automotive industry. We already know there's quite a lot of computerization in that industry, but this can be used, machine learning, AI, to basically come up with perhaps better ways to automate the production line. Another client of theirs used it to improve the efficiency of their investment trading algorithms, which I think people might have heard about anecdotally in terms of what are the application cases for it. Another one is, this is really important in what's happening in the world today, is streamlining supply chain and logistics processes. That one could say that will be helpful once they get going again, but once they're more efficient, then this of course will look to increase those efficiency even more. And then making product marketing decisions based on market analysis. So there's many applications. Companies are basically kicking the tires with machine learning AI to find out if it's something that can help them produce their effectiveness, their efficiencies, and as is stated here, to basically drive revenue and save costs, etc. So let's go to the next slide, please. So what are the agreements that you experience? And this might be oversimplifying it, but I've only got 15 minutes, so I guess I have to oversimplify it somewhat. So the first type is an evaluative services. This is like kicking the tires, so to speak. And this is where a company is saying, I think we might be able to improve some of our processes. We have a lot of data. We'd like to understand how that would work. And so these companies will often enter into an evaluative services contract with the AI machine learning service provider. And it oftentimes will be an evaluation of the user's data. And again, I don't want to turn you into a data scientist, but a lot of data that these companies like LTML look at, it's not very useful in its current form. So some of that work, statement of work under an agreement like that might be just looking at your data and basically recasting it, so to speak, so it's more usable. So that's often, again, that first stage. And the user often owns the IP. The service provider, in terms of the trade-off, doesn't really care too much at this stage. There's not really much IP that's being developed. And as a result, it's more like a beta test agreement that you might be familiar with. There's really no warranty or indemnity. Now, a development services is typically the next agreement, might be part of the evaluative services agreement, having two different parts, if you will, to one agreement, but typically it's a separate agreement. And this is where you've had obviously some positive results from the evaluative services agreement, and you're very interested in finding out, well, what could we do with a machine learning AI solution that would improve the efficiencies of our business, for example. And we'll get into, not we, you maybe later in the Q&A we'll get into, I'll get into a bit of ownership of IP, and there's different perspectives. So I just wanted to note it for right now. And they're really quite important to understand why the companies have different perspectives, but they do, and a lot of it's based on how we used to do things in this space. So let's go to the next slide, please. So really, when you look at these kinds of agreement, what's really important are the different components really as part of this solution. It's not different from the conventional software licensing approach or even a software development approach because it's more of an iterative and dynamic process, whereas the typical kind of software licensing development we're used to is more static. You're looking for a certain piece of software that creates certain results for you, and it's going to be the same because the programming doesn't change. Now, a fundamental aspect of the work that these companies do in this area is that most of what they're developing is quite dynamic. Now, in terms of the ownership questions, just like the questions we ask in a typical technology question, but somewhat different. Maybe I'll start by, in terms of the components, really what it is. The AI solution is the tool that's used to produce the desired outcome. Like, why are you entering into this whole exercise? And it's usually a machine learning algorithm. And in a more futuristic state, when we get to that, it could be a deep neural network, but that's more on the drawing board, more scientific, more futuristic, not a great practical application now. Training data, this is the data that's used to train the AI. Remember, I mentioned the system really, along with the instructions that are provided to it. And then there's production data. That's the data that's data sets that's entered into the AI to produce the certain output that you're seeking. So the output is the outcome after you've entered the production data. And then over time, you can have AI evolutions in the sense that if you have an AI, the solution itself can evolve in terms of additional information that is learned by basically running this data through different models and having sometimes the data create additional data patterns that are then part of the overall solution. So then when you identify the components, and it comes down to key questions that will help you in the exercise, if you're looking to engage an AI ML provider, who provides the component, who's using it, and you remember the components I just mentioned, how will the components be used, and who owns the component. And at the top, I just talked about some of the approaches. I mean, I get it. Sometimes companies will approach this from the basis of a size differential. We're a big construction company. We want to use our form of agreement for this. It just doesn't work. I mean, you know, you can get to the spot where you need to, but it just doesn't reflect the kinds of exchanges in terms of these different models I described or components I described to you, and then the different ways to talk about ownership from an IP perspective. So let's go to the next slide, please. So in terms of the user perspective, and I'm certainly not trying to be pejorative or anything, I think part of being good in this space, if you're a lawyer and you're acting for a company that's interacting with a machine learning AI company, is to understand the basics, and I'm trying to give some of those to you. So it's kind of a mindset that will help the negotiation. And again, it's just understanding some of those basics that I described to you: big data, machine learning, artificial intelligence, and then the different components, and then looking at when IP is created as you move along from, as I mentioned, the developmental service agreement comes later, trial agreement comes first, and you're going through a process of trying to identify the data, and then how you can use the data, the patterns that emerge in the data, and then developing algorithms that are then going to be part of your solution that you will use to solve business problems for your company. So let's go to the next slide. This is just, I mean, I find this interesting, and it's what sometimes us IP lawyers focus on, right? And so if you do have an AI that is creating code on its own, you've developed a program, and this is, again, where you're getting to that general AI or the type of anti-technology concerns that people have in terms of the future run by robots that are basically learning like human beings. And we're not there yet, but there is a concern about that. And currently our IP laws don't address that, because they talk, as I've indicated in this slide, that authors or inventors, and referencing the different statutes that we have in Canada and other countries as well, they refer, or they infer at least, that these persons, shall we say, have to be a natural person. But if you have an AI creating additional data, information, new code, then arguably that's not a person, it's not an individual, sorry, that's creating that, it's some other entity. So there's some current problems with our IP legislation, but as I mentioned earlier, we're at a stage of developing narrow AI, so it's quite focused, and we don't have to worry about this yet, but it's coming. Next slide, please. So then you have all these different types of data. And of course, customers are always concerned about their data maintaining its form, and that they always have to own it. And you're never going to find a machine learning AI company that says they want to own your data. That's sacrosanct. Now, what's going to happen, I mentioned before, is you're going to have these different components, and one of them is the training data. And so that's a question about who owns that. That's probably going to be related to the customer data. And then what's most important for an AI company is the metadata. And what is metadata? It's basically just it's data that's describing other data. It's basically the science of looking at what are the elements, what are the components of a piece of data, a string of data. And that tells a machine learning AI company a lot of information. And it's information that they are looking to replicate on the basis that it will improve their models and their software, or your software if you're the user licensee, right? So it's what it's really after in terms of what data do they want to own. And usually most customers we find in negotiations don't care so much about that. They almost look at it, you want to own that, that's great. What they do care about when it gets to personal information, of course, and of course we have laws that apply already in terms of the use of personal information and restrictions on how that can be used. Currently, the EU's GDPR, which is the most masterful piece of privacy legislation, data security legislation in the world, and currently it has a prohibition to protect individuals, as you can see, in terms of carrying out solely automated decision making. And the biggest or the best example of that is profiling. This is, again, some of the negativity that comes out of this space is use of AI to profile people. And there's been some nasty instances of some large companies in their early days working with machine learning AI, where profiling has been an issue. And so that has been enshrined in the GDPR, and Canada has a Consumer Privacy Protection Act on the book, so to speak. I think it's its second reading. And then Quebec has recent amendments to its Privacy Act as well that will impose measures of transparency and consent that we don't currently have. Now, when it comes to data, the equation and who owns what and how to separate it out, if you're able as a provider to pseudonymize that data, easy for me to say, not, that can be useful in terms of giving the customer the satisfaction that you're not using any personal information, you're not using confidential information in terms of its raw form. And so if you get to that state, that's helpful. It's also useful under the GDPR and the CPPA in terms of dispelling some of the notions of being offside of that legislation. So let's go to the next slide. I'm just looking at my time here. Okay, I better hurry up. So with the warranties, you can imagine, you remember I'd mentioned about the AI solution as dynamic. So you can understand then typically when you look at a software agreement and you say to yourself, okay, well, we have the specs and this is how the software is going to perform and how it's going to function. And you look to tie the two. And that works in the static situation. But if it's dynamic, and you remember I've talked about how you have an evolvement of this AI based on learning from the data analysis and the patterns, and then making certain suggestions or improvements based on that, it's hard then to have a warranty that you're going to build into it that's going to be satisfactory to the licensee. And you can see, I can see now, my first point was so important that I repeated it as my last point. So there you go. Let's go on to the next slide, please. So as much as we're talking about IP ownership and licensing, related to it as the lawyers, the IP lawyers, especially in the crowd would know, there is also the matter of IP infringement. And the traditional approach that I've mentioned is, and I'm sure people would be very familiar with these, they just don't apply, again, because the dynamic nature, not always apply. It's not black and white, but they don't always apply well in terms of looking at an ML AI service provider agreement, because the modifications and combinations, as I've indicated, they will occur with AI solutions. So you can't keep them so discrete. And it's not to say there are no answers to this, but that the parties have to, figure out how these matters are resolved in this different model. And as lawyers, business people related to this area too, or practicing this area, it's about control. Who controls the risk? That hasn't changed. It's just that it's applied differently when you're talking about these kinds of solutions. So that's going to be really important. Look at the models, look at those questions I mentioned to you, and then talk about who controls the development and how is it used, how is it developed over time. Next slide, please. All right, well, that's it. I went kind of quickly. I did my best impersonation of John F. Kennedy, one of the fastest public speakers apparently in the world, so just so I could get it done in time. So I hope there was some useful information for you folks, and I think you'll find some good information in my slides that I went over quickly. So thank you for listening. Next, I want to introduce my colleague, Paul Denboeuf. He is a senior patent agent with our firm, and Paul's topic is going to be protecting software implemented inventions from copycats. Over to you, Paul. Thanks.
Great. Thanks a lot, Tom. That was a great talk. So as Tom mentioned, my topic today is going to be protecting software implemented inventions from copycats. So today's topic is going to have a particular focus on patent eligibility. And patent eligibility is something that is generally jurisdiction specific, but today we're going to talk about particularly software implemented inventions in terms of their eligibility in Canada and the United States. So let's begin. Next slide. So just before we dive into patent eligibility, I want to give you a little bit of a spiel as to why you would want to consider patent protection for your software implemented inventions. So software implemented inventions could be protected by a trade secret if there's no detectability. So an example of this would be Google's search algorithm. So pretty much everybody uses Google perhaps on a daily basis, and you know how it works. You input your search terms and then Google gives you your search results. Now, as to what actually happens behind the scenes and what makes this work, you probably don't know what that is, and you probably don't have any way of figuring that out. And because you have no way of figuring that out, it is possible for Google to just keep that a secret, even though everybody uses it perhaps every day. Nobody can figure it out, and so it's possible to keep it as a trade secret. So trade secret protection is possible if there's no detectability of the invention, but there's also risks involved with trade secrets. So if, let's say, a rogue employee at Google lets the cat out of the bag, and then everybody knows what the Google search algorithm is, then you're not exactly protected anymore. And the other thing is that, by and large, most software implemented inventions do not have this unique ability to stay a secret. So in many cases, it is possible to figure out what is actually happening and how something works. Software implemented inventions can also be protected by copyright. So, but the problem with copyright is it's extremely limited. So anybody who has any experience as a software developer will know that there's maybe more than 100 different ways that you can code an invention, a software implemented invention. So there's different programming languages, there's different structures, there's different ways you can basically code basically the same or functionality. So copyright protection is extremely limited. By contrast, patent protection gives you much broader and stronger protection than copyright. So patent protection is really what you need to be thinking about. So the question today is, are software implemented inventions patent eligible? And the short answer is absolutely yes. And this is a big thing today. So looking at last year, for example, the United States, a majority of patents granted by the United States Patent Office were software related. So the stat I've seen is about 63%, in fact, are software related. So the answer is a resounding yes. Software implemented inventions are patent eligible. The long answer, because if I leave my presentation here, it's only been 2 or 3 minutes. The long answer, which I'll be diving into, is it can depend on the invention, and there's some areas of technology that can receive a certain amount of scrutiny. So it definitely does not mean that software implemented inventions are not patent eligible, but it does mean that depending on the invention, there could be a little bit of scrutiny. Next slide, please. So we're going to start out by talking about patentability in Canada. So our Canadian Patent Act is actually very vague. The relevant sections here, Section 2 and subsection 27A, they don't actually say anything specific about software patent eligibility or even computers. The patent rules are not helpful either. They don't say anything. So current practice is roughly based on existing jurisprudence. And there lies, unfortunately, another problem where Canadian jurisprudence is actually not very big, okay? And the existing jurisprudence that we have, well, it kind of leaves a lot to be desired because there's a lot of holes in it, and there's a lot that we don't necessarily know just because there's not a lot of jurisprudence. And so what the Patent Office does in Canada is, based on the jurisprudence, they come up with their practice notes, which is available for patent examiners and also practitioners like myself. And we all tend to, follow this practice roughly. So under current practice, patent eligibility of a software invention often hinges on whether a tangible feature is deemed part of the actual invention. And the reason for this is, when we look at the jurisprudence, there's a so-called physicality requirement in the jurisprudence. And an example of this would be the Schlumberger Federal Court of Appeal decision back from 1981. So this was a computer implemented method of combining and analyzing borehole measurements for oil and gas exploration. But in essence, it was just calculations. Okay, so somebody would input some numbers into the computer would do some calculations, and you get some output. And what the Federal Court of Appeal said was that there's nothing new in using computers to make calculations. And if those calculations were not to be affected by computers, but by men, the subject matter of the application would clearly be mathematical formulae and a series of purely mental operations. The decision suggests that a computer does not contribute to the patentability of an invention, especially when it is used only to execute calculations. More recently, we had a more favorable decision in the Amazon Federal Court of Appeal decision. This dealt with Amazon's one-click invention, and you guys are probably familiar with this invention. When you do your online shopping, which most of us have done, especially during the pandemic, you can use Amazon's one-click invention feature where just one click of a button can result in you buying, perhaps impulsively, a new product or service, and maybe it gets delivered to you the very next day. And this works by saving some of your information, such as your credit card number, your shipping address, etc., and storing that. And there's some interaction between your client computer that you're using and a server. And using this stored information, they're able to process your transaction and ship out to you whatever product or service that you are trying to buy. This Federal Court of Appeal decision was interesting because it said arguably Schlumberger, that's a decision we just talked about earlier, which is just calculations, is distinguishable because a new one-click method of completing an online purchase is not the whole invention, but only one of a number of essential elements in a novel combination. The Federal Court of Appeal asked the Patent Office to re-examine the patent application on an expedited basis with a mind open to the possibility that a novel business method may be an essential element of a valid patent claim. In response to this mandate, the Canadian Patent Office went ahead and allowed the application. So although the Federal Court of Appeal did not explicitly say that Amazon's one-click invention was patent eligible, that's in essence kind of what they said. And they said, hey, Canadian Patent Office, please go ahead and examine this and keep in mind that this novel business method, it may be part of this valid claim. So what we get from that is that a software implemented invention that goes beyond mere calculations, so not just calculations like in the Schlumberger decision, but something a little bit more. So like with Amazon, you had a client server and you had some sort of messaging between the two to complete the online transaction. Well, that can be patent eligible. So roughly speaking, the practice right now is if an actual invention does not include any tangible features, so it's just calculations, then it's probably not patent eligible. But on the other hand, if it includes tangible features that goes beyond mere calculations, then it is patent eligible. So if we go to the next slide, we're going to go through a few examples. These are examples that the Patent Office actually releases. So I'm just going to kind of go through a few of these because they help to kind of emphasize what I just mentioned, that in essence, what you need is to fulfill this physicality requirement in a way that goes beyond mere calculations. So example number one is a computer implemented method of analyzing data from seismic measurements comprising, and step one here is performing seismic measurements. And then there's other steps here, which I won't go through, but in essence, it involves calculations using the seismic measurements and then displaying a result. Now, what's interesting here is that the way in which the seismic measurements are done does not need to be new or inventive under the new guidance. So you could be doing this step with a generic and known sensor or device. It does not need to be new or inventive. And so despite that, because you have more than just calculations, you have some physicality, you're actually measuring something in the real world, in this case, seismic measurements, this results in the claim being patent eligible. In the next example here, we have a computer implemented method of drilling for oil. And this similarly involves calculations, but instead of having a step for actually receiving the seismic or performing the seismic measurements, this has a step of drilling for oil based on the results of the processing. And again, I want to emphasize that this does not need to be new or inventive for this claim to be patent eligible. Rather, it just needs to be something physical. Now, I don't want you to get confused and say, well, you can claim anything that is known. So that's a separate issue. So patents still need to be new, useful, and non-obvious. That's a basic criteria. But just in terms of patent eligibility of a software implemented invention, you don't need this physicality part of it to be new. Okay, next slide. So here we have another example. And in this case, we actually do have just calculations. And then you're going to say, well, hold on a minute. You just said from the Schlumberger decision that if you have just calculations by computer, that's not patent eligible. Well, that's not always true. So in this case, you have encoding being done by a digital signal processor, digital video data using algorithm Y. And in this case, algorithm Y is described to be very special in that it performs data compression in a very special way that achieves the same signal to noise ratio as existing methods, but using fewer processing steps. And so if you're improving the functionality of the computer, so let's say it's faster, it's more efficient, it's more energy efficient, it uses less memory, whatever. If your calculations is solving a computer problem, then arguably it's patent eligible, and that's what this example demonstrates. Okay, next slide. So in terms of patentability in Canada, the opportunities are vast. So for any invention that has physicality going beyond mere calculations and or is solving a computer problem. So there's many blockchain and artificial intelligence patents out there. I listed off just a few of these just as an example. So the point here I want to hit home is that modern technologies, many of them can be software implemented, and by and large they are patent eligible in Canada. All right, next slide. So what about the United States? Well, similar to Canada, the statutory law is quite vague and doesn't actually say much or anything, rather, about software or computers. And again, current practice is largely based on existing jurisprudence. The US does have more jurisprudence than Canada, and so the picture is a little bit more clear, but that said, it's still a little bit unclear. Under current practice, patent eligibility of a software invention often hinges on whether the invention is directed to a so-called abstract idea. An abstract idea is a judicial exception where there's enough jurisprudence that says you cannot patent an abstract idea. So generally speaking, it's important to assess whether an invention is directed to an abstract idea. And so the million-dollar question is, well, what is an abstract idea? If we can nail that down, then we know what we have. So this is where, unfortunately, the jurisprudence is not entirely clear. So the Supreme Court of the United States has ruled on this in 2010 and 2014. So there's a Bilski decision in 2010 that said that hedging losses in one segment of the energy industry by making investments in other segments of that industry is an abstract idea that you can't patent. And in 2014, we had a different, but maybe somewhat similar area of technology invention where mitigating settlement risk by using third-party intermediary is an abstract idea that's not patent eligible. Next slide. So the good thing, though, is that the Supreme Court did give us some amount of framework for deciding patentability. And this is what I have here up on the slide here. But again, the difficulty is that we still don't know what exactly is an abstract idea from the jurisprudence. So here in this flow chart, what's circled here is the so-called judicial exceptions, and that would include an abstract idea. And so if the answer is that your claim to your invention has an abstract idea, then it actually becomes difficult for that claim to be patent eligible. Whereas if it doesn't, then you're good. There have been some favorable Court of Appeal for the Federal Circuit decisions since those Supreme Court decisions that shine some light on abstract idea. And we had a new director that joined the USPTO a couple of years ago, and he was a patent attorney, an engineer, and he was quite pro-patent. So under his direction, we got new subject matter eligibility guidance in 2019 that came out to be much more patent friendly. And the result of that is that a practical application is not abstract. Next slide. So in particular, the box I had circled in the other slide, which is a determination of what is an abstract idea. This was divided into 2 prongs. The first prong is still assessing whether your claim recites an abstract idea, but the interesting part is the second prong is, are you actually reciting elements that integrate the abstract idea into a practical application? And the guidance here, I won't read it all, but it basically says that it doesn't matter if your claim is reciting known or conventional components. If those known or conventional components recite the abstract idea in a way that provides a practical application, then you don't have an abstract idea. So it's a bit of a weird way to word this. It's kind of like saying, okay, you have an abstract idea, but you don't. So in terms of what is a practical application, the examiners are very generally pretty lenient on this. The guidance says that, you know, any improvement in the functioning of a computer or an improvement to other technology or technical fields can be a practical application. Next slide. So because of these guidelines, which are more patent friendly, the opportunities are vast for software implemented inventions that provide for practical application. And so some examples here, much like in Canada, blockchain and artificial intelligence, that's patent eligible. So next slide. So in conclusion, software implemented inventions are patent eligible. So in Canada, if you have physicality going beyond mere calculations, or the United States, you have a practical application that generally is going to be winning the day. Patent protection can provide broad and strong protection, as I mentioned at the beginning. So you should consider filing for patent protection early and before any disclosure of the invention. And with that, I believe I'm finished. I guess
Fantastic.
we can open it up to questions.
Yep. Perfect. Thanks, Paul. Thanks very much. We do have some questions in the chat, and so we will now get to those questions. The first question we have is for Sam. And Sam, the question is, while I don't think the average person would confuse Herbs R Us with Toys R Us, if Herbs R Us had used a backwards R, which has become synonymous with Toys R Us, would the court have found otherwise?
Thanks, Jacob, for the question. The answer is no. They would have made the same decision. The court actually discusses this in its decision and talks about the similarities and differences between the 2 marks. And the court does mention that the R in the Herbs R Us is the sort of correct spelling of it. But the legal test is that you have to look at the marks as a whole, and it's the overall impression of the marks on the casual consumer that is going to be reviewed by the court. It's not the little differences in them. So even if the R was backwards, the court is still going to say they resemble each other, but then they're going to go to the next part of the test, which is the nature of the goods and services and the nature of the trade, and they're going to look at the different factors. So the court in this case, if Herbs R Us had the R backwards, they'd say, yeah, these resemble each other, but we still have to go to the nature of the goods and services and the nature of the trade. And I still think that they would have found no trademark infringement. So the big picture from your question, I think, is that the law doesn't parse out individual aspects of a registered mark and an infringing mark. The casual consumer is going to look at them as a whole, and you're not going to take little individual aspects. It's the first impression that matters.
Super. Thanks, Sam. We have another question from David, and this one, Paul, is directed to you, although if you like, I can also add from a copyright perspective. The question is, you say copyright is not a strong means of protection, as there are always other code combinations that do the same thing. Does this same reality not also undermine the usefulness of patent protection?
Yeah, that's a great question, David. So what I would say is, copyright is very specific to the exact way that something is written. But patent protection is really protecting a kind of a broader concept. So in terms of the actual implementation, if you look at a patent claim, it's not going to say anything about how the software is actually written or coded, and that leaves it open to any number of possible implementations. So really a patent is its intention is to cover a broad concept. So, if I have a mobile phone here, for example, let's say you have some software app running on here, you can recite the functionality of that software app without saying anything about how the software app is actually programmed. Details such as that are basically superfluous for the purposes of your patent claims.
Yeah, that's great. And I would just maybe just add a tiny bit to that from a copyright perspective, Paul, just to highlight the fact that copyright protects the reproduction of the work or a substantial reproduction. So exactly to your point, it has to be an exact copy or substantially the same copy of in order to benefit from the protection from a copyright perspective, whereas from a patent perspective, as you said, it's a much broader form of protection for the implementation. So, so thanks for that. This question, Tom, is for you. Do you have a recommended definition of intellectual property rights as a defined term in a commercial AI software agreement?
Sure. The answer is yes, but it's complicated because of course it's tied in with matters of data and indemnity and warranties and all the rest of it. So yeah, I could probably help you. Probably the best thing to do, and I responded to someone else that sent a text. I gave my email address, and I can't rattle it off right now, or I could, but my colleagues would probably say, well, that was pretty good, Tom, but imprecise. So if you could send me an email, then I could help you out. It's tom.sides@dentons.com. And I think, Panyota, we've got that information available to everyone. Okay, so that's what I would suggest. I can help you, but let's just deal with it after we're done here, if you don't mind. Thank you.
Yeah, super. I see one more question. I think, Sam, this one's for you. And it's a question about licensees, trademark licensees, and whether they can bring a lawsuit for depreciation of goodwill.
Yeah, so that's a really good question, because a lot of times you have trademarks licensed off by a parent company to a sub, or you have just a holdco, or you have someone using trademarks themselves and they're licensing it off to a franchisee. So in the Trademarks Act, there's a specific section that says that it's under section 50 sub 3 that says that if trademark infringement occurs, I'm just pulling up the exact section because I just want to get the wording of it exactly. So yeah, if trademark infringement occurs, a licensee can call upon an owner to take proceedings for the infringement. And if the owner refuses or neglects to do so within 2 months of being called upon, the licensee can institute proceedings for infringement in the licensee's own name. And then you make the owner a defendant in the proceeding. The important part of that section is that it only refers to infringement. It doesn't refer to depreciation of goodwill. So statutorily, if you're a licensee of a trademark, you don't have any rights statutorily to require that a licensor take up a depreciation of goodwill claim. So if you do have a contract as a licensee, that's a good place to put that language in, so you're protected contractually, because statutorily you can't call upon the licensor to take that claim, and you don't have the ability to take it over yourself too. It's only in case of the trademark infringement. So put some language in your contracts to cover those off, to cover a depreciation claim off for sure.
Thanks, Sam. I actually have one question for you, Paul, just sort of as a practical matter for our participants. When a company is going to be reaching out to you from an invention mining perspective in order to capture an invention and actually get to the patent drafting and filing to protect their invention, what is it that they should be prepared with to come to you with in terms of information or material? And I raise this because it's such a common question that we get when we have conversations about these kinds of things. So I just wondered if you could share a few points on that.
Yeah, that's a great question, Paniota. So with any invention, what we really need is an enabling disclosure that is complete enough that we can really describe the invention in enough detail so that somebody skilled in the art could, read this and figure it out, and with enough detail in there so that they can actually go out and practice invention themselves. So what you don't want is basically, oh, I have an idea, it's a pie in the sky, here I want to invent a time machine. Okay, it's very simple. We have means for going back into time to 2009, then I can buy Bitcoin, come back to the future, and then I'll be super rich. Now, functional claim language like that, let's say means for going back in time, that is actually permissible. But what you need ultimately is to be able to describe the structure behind that functional language. So oftentimes inventors have their invention in their mind in terms of function. So we need something to do this, something to do that. And that's great, but we also need the actual structure. So in the case of a time machine, you would actually have to provide some structure as to how you would actually do that. Now, in the law, 35 U.S.C. 112 allows a functional language, but paragraph 6 of that same section says if you haven't described the actual structure for doing that, then your claim's invalid. Now, in the case of a software implemented invention, you may ask, well, what is structure? What is structure of a software implemented invention? And what it is actually is the kind of the processing steps, a flow chart or signaling diagram. So maybe step 1 is calculate variable X. Step 2 is variable X greater or equal to some defined threshold. If yes, go to step 3. Step 3 is you transmit some message and do whatever, or else go to step 4 where you do something else. So knowing the actual processing steps and what's actually involved in terms of the invention is very helpful. So to get that in terms of software implemented invention, flow chart or signaling diagram or something like that, that basically explains the innards and how the invention actually works in enough detail so that somebody would understand it and be able to practice it. That's what's really required.
Fantastic. Perfect. Well, we're just about at time, and I think we have covered, I'm going to just double check. Yes, we've covered all the questions that came in. So I just wanted to thank all of our speakers and our attendees. And as Tom mentioned, we would be happy to answer any questions you may have for any of us on the content that we shared with you today, or the content that we shared with you yesterday. Our bios are up on the screen, our emails are up on the screen, but also on the webpage for the webinar and on our website. There will be a survey, and we do appreciate you taking a couple of minutes of your time to fill out that survey and give us your feedback so we can continue to improve our delivery of content to you. So thank you for making time to be with us. We hope this was helpful, and we will end our session right here. Take care, everyone.